We've got some breaking legal news today. First, a New York appellate court has suspended the law license of former New York City mayor and personal lawyer to President Trump, Rudy Giuliani. Once a top federal prosecutor, he will now face disciplinary proceedings to determine if he should be permanently disbarred. Plus, following a Supreme Court ruling on Wednesday, police officers pursuing people now have limits on when they can enter a home without a warrant. And in what is described as a racial equity move, the Portland, Oregon Police Department is changing its policy on traffic stops to focus on violations that threaten public safety. I, of course, have to bring in veteran prosecutor and legal contributor Paul Henderson to help break down some of this legalese. Paul, let's start with Giuliani. A New York State appellate court suspended his law license after a disciplinary committee found he made demonstrably false and misleading statements about the outcome of the 2020 presidential election. In its decision, the court said that Giuliani's behavior represented an immediate threat to the public and that he had directly inflamed the tensions that led up to the Capitol riot. Now, how likely do you think it is that Giuliani will be disbarred?
Well, I think there is a high likelihood, and I think that that is the least of his worries, because today, or when he went to court, may have been the last time that he actually saw the inside of a courtroom as a lawyer. And he's got plenty of other issues following him that could bring him down or send him on a different pathway. Part of the issue here, though, is I think what's really interesting about this is that this is about Giuliani specifically and not Trump, right? He was representing Trump and he was advocating on behalf of Trump, but because of his profession as an attorney, we are held to different standards and are independently responsible for those actions and for that amount of credibility. That's what he's being suspended for right now and possibly disbarred for. And there is, I would say, somewhat of a fine line in between advocacy versus zealous representation. And he has fallen outside of that zone of representation. And that's why he's being held accountable. And I would say that the other thing that I would point out is, we always have three different tracks of accountability. There's civil liability, there is criminal liability, and then there is administrative accountability. And this is one of the administrative accountability tracks for attorneys. As an officer of the court, he is bound to represent himself in a way that is more credibly than this panel has found. And this is just the tip of the iceberg, because we do know that there are still ongoing investigations at a local, state, and federal level involving Giuliani at the criminal tracks. And so I think this may really have been the last time that we've seen him appearing inside of a courtroom as an attorney, and that's what it is.
So that brings me to the next question. The court's statements about Giuliani's behavior representing an immediate threat to the public and that he had directly inflamed tensions in the lead up to the Capitol riot sounds like how an indictment would read, no? So do you think Giuliani could be facing criminal charges?
I do, and it does sound like an indictment, and I think it highlights the point that what he was saying and the message that he was presenting was actually dangerous. They took action based on the dangerousness of that message. That's why he got suspended. That's why he might be disbarred. I think, again, that that's just the foundation that will be used and likely to be used, as you so wisely pointed out, just like the language that you would find in an indictment for criminal conduct based on those representations. I think it's not a mistake that the court used language and a basis like that to make their decision. And I think we'll hear that decision used as a basis for the rest of the charges that are still pending related to the investigations that are ongoing related to Giuliani.
Now, Paul, you and I talk all the time about prosecutorial misconduct and how rare it is that prosecutors are held accountable. In fact, there have only been 4 cases, just 4 nationally, where prosecutors have been disbarred for misconduct that led to wrongful convictions. Now, I'm not saying Giuliani shouldn't have had his license suspended, but you have prosecutors who sent people to prison for decades and face no consequences. Shouldn't suspending and disbarring lying attorneys be a regular thing and not a rare occurrence?
Well, when it actually happens, I believe so. And now that we have standards for that, and we've had standards for a while, it just has not been a pathway that have been used very clearly. But I do believe the tide of that has changed. I think prosecutors, like law enforcement agencies, are being reviewed with new standards these days, because once we know better, we can hold these agencies and individuals more accountable for their behavior and as technology increases, as known behaviors are known, just like bias, then we can look back at decisions that are made inside the courtroom to hold more folks accountable. And it shouldn't just be the prosecutors. As we hold law enforcement accountable, as we hold prosecutors accountable, we have to hold juries accountable, we have to hold judges accountable in many of the same ways. I believe that that's the only way that we're truly going to reform our justice system. It can't be just one of the individual actors. We have to look at the entirety of the system if we're ever going to get to the solution, which is a race-neutral outcome in our criminal standards. That's the goal. And so I do believe that we're going to see more than what we've seen in the past, at least from prosecutors, and certainly with law enforcement, and hopefully with judges.
All right, let's turn to the Supreme Court decision on warrantless searches. On Wednesday, the High Court ruled that officers in pursuit of someone suspected of a misdemeanor offense are no longer allowed to enter that person's home without a warrant. Does this decision go far enough to protect people's right to privacy, Paul, especially for Black folks whose rights are violated at a higher rate?
Well, I think it raises the standards to evaluate how police act and when they act, and that's really important because what the court was doing here is balancing and making a new definition of what defines a public safety risk. We already know that running into an unknown personal residence is a high risk, both to the residents and the folks that may be in that house, but also to the officers themselves. This is not best practices to do that in a cavalier manner. There have to be clearer standards about when that can be done. And quite frankly, this isn't something that even has a long history. It wasn't until 1976 that the Supreme Court allowed folks to run into a resident like this in a hot pursuit. What I think is really interesting is looking at that discretion associated with law enforcement and the race disparate outcomes from its use. That's the issue. And so law enforcement disproportionately uses the high risk or the hot pursuit opportunity disproportionately against communities of color. And here's the thing that I think is also something that's important for us to point out. That hot pursuit standard, which has been validated since 1976, can easily be elevated from any other thing that comes along, like an infraction, like jaywalking. And you can say as an officer, oh, he gave me false ID, or he wouldn't give me his identification, and now it's suddenly a misdemeanor. That misdemeanor can be used as a basis to get into a hot pursuit, and that's how you have elevated and escalated consequences that are subjectively applied towards communities of color. And so I believe that this ruling and establishing standards will go a long way in protecting and institutionalizing policies against that don't hurt communities of color. So I do think that it's a first step. I do think that establishing this foundation and a clear definition of what's allowed by law enforcement is helpful, and it just shines the light on where I think the court would like to go in terms of pressure that they feel to reform law enforcement agencies and justice reforms in the first place. And so I like this decision, and I think it's more helpful than not. And as with most decisions, I like to look at them with a critical eye, with an overlay of race analysis to determine whether or not it's more beneficial to the broader community, including disenfranchised communities, and especially communities of color when we're talking about anything related to our justice system.
All right, so we've got a few minutes left. Let's go to Portland, Oregon. Police are being advised by Mayor Ted Wheeler not to pursue motorists for low-level traffic infractions like broken taillights and expired tags. Also, if police do end up making a stop, they have to receive recorded consent by the motorist before searching the vehicle. Now, the mayor said the goal of the changes is to increase racial equity. How much of an impact will these changes have on the racial disparities in Portland's policing?
Well, I think it is going to have an impact because these are some of the known disparities when we talk about race. And, a lot of times when I talk with different jurisdictions and they're curious or don't know if they have race disparities in their jurisdiction, I ask them to pull any of the information over their stop data or pull any of the information about any of their use of force data and then overlay race to determine. And this is one of the clearest and easiest ways to determine if your jurisdiction has these issues and these problems, as do most jurisdictions. I haven't found a jurisdiction that doesn't have these issues, but communities of color are pulled over and stopped disproportionately from everyone else. And so this is a good ruling. And here's the problem. Those stops that can be validated, and we call them pretextual stops, are the basis and the foundation where those stops get escalated into use of force. And this is part of the problem with race disparate outcomes in policing. And so this really does speak to that issue and redefine the standards that I think are at the heart of the discussions that are taking place right now about what do we want police doing. Are these really public safety risks when we're stopping people for speeding or having expired tags or having a tail light that's missing? That's a ticket. That's a whole different analysis and not what we want police doing with their time in terms of defining public safety. And I will say, I think what's interesting to evaluate in terms of talking about, one, ending pretextual stops, but two, redefining what we want police to be focusing on in our communities that we are paying for. But this folds into the defund the police analysis, where we want to reevaluate where we're sending police and what we want them spending their time doing. We want police stopping bank robbers. We want police stopping shootings and robberies. Do we really want police enforcing jaywalking and enforcing broken taillights and enforcing speeding violations with their time that unfortunately and frequently escalates into race disparate outcomes, including use of force in this country? I think that this determination is a first step in addressing those things. And I know my jurisdiction is doing a lot of work right now, again, to address pretextual stops and really talking about it. You're not going to fix it if we're not making decisions about it and trying to eliminate what we want, which is better policing and better law enforcement in this country.
Veteran prosecutor and BNC's legal contributor, Paul Henderson, as always, thank you so much.
Thanks for having me, Yodit. It's a pleasure.